Hello friends, today we will discuss section 32 and section 33 of Indian Evidence Act in two parts. In the first part, I will discuss exclusively the sections and the illustrations, and in the second part, I will discuss some landmark case laws on section 32 and 33. Section 32 and 33 are basically known as dying declaration, statements by persons who cannot be called as witnesses. I am reading the section. Case in which statement of relevant fact by person who is dead or cannot be found, etc. is relevant. In general cases, we know that every statement have to be proved before the court, but when the person who is dead or cannot be found, how his statement will become relevant and in which cases their statement will become relevant. I am reading the section, read with me. Statements, written or verbal, of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expenses, which under the circumstances of the case appears to the court unreasonable, are themselves relevant in the following cases. So there are four conditions. Number one, either the person is dead, or number two, who cannot be found. Number three, who has become incapable of giving evidence. Mental problem, paralysis, a speaking problem, anything can happen, or whose attendance cannot be procured without an amount of delay or expense. Just say I made a statement before any authority, before any person, and thereafter I went to a foreign country and I did some crime over there, and I have been imprisoned for 5 years. So my presence cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. Number one, when it relates to cause of death. In the first para, we learned what are the cases when without the personal presence of the maker of the statement, their statements will become relevant. Now, in subclauses, we will learn what are the cases when they will become relevant. Number one, when it relates to cause of death. When the statement is made by a person as to the cause of his death, or to anyone, or as to any of the circumstances of the transaction which resulted his death. In cases in which the cause of that person's death comes into question, such statements are relevant whether the person who has made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. So in subsection 1, it categorically states that when it relates to cause of death, death of whom? Death of the person who is the maker of the statement. When the statement is made by a person as to the cause of his death, say, I set fire on B by pouring kerosene oil on him. B is in deathbed in hospital. Doctors are trying tremendously to save his life. During that time, B said that Prithwishganguli poured kerosene oil on me and set fire. At that point of time, B told about the cause of his death or as to the circumstances of the transaction which resulted in his death. Later, after making the statement, after 2 days or 3 days, B died. So this statement of B will become relevant, that Prithwishganguli poured kerosene oil on me and set fire, because this narrates the cause of B's death and explains the transaction out of which the death of B caused. In which case this statement will become relevant? In cases in which the cause of the person's death comes into question. When there is a case which involves the question, the cause of B's death, in that particular case only, this statement of B will become relevant, not in other cases. Such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death. B died after 3 days of making this statement. Doctors were tried a lot to save him, and B was also struggling. B was not under the impression that he will die after 3 days. And whatever may be the nature of the proceeding in which the cause of his death comes into question, it should not be only a murder case against me for murdering B. It can be any case, but in that case, the cause of B's death should be a question. Not the death of B should be a question. Whether B died or not, that should not be the question. The question should be how B died. What happened to B for causing his death? The question should be the reason of his death, not his death. In any case, when the reason of B's death is in question, this statement will become relevant. Number 2, or is made in course of business. When the statement was made by such person in ordinary course of business, and in particular when it consists of any entry or memorandum made by him in books kept in ordinary course of business, or in discharge of his professional duty, or of an acknowledgement written or signed by him of receipt of money, goods, securities or property of any kind, or a document used in commerce written or signed by him, or the date of a letter or other documents usually dated, written and signed by him. Say, I am a police officer and on a particular day I was a duty officer of a particular police station. when Mr. X came and filed a complaint. I took the complaint, I put stamped on it, I signed, I put date and entered the complaint in the formal GD book of the police station, which is maintained in ordinary course of business. In every complaint received by the police station should be entered in that GD book. So now, after 2 days, I died due to some cardiac arrest. Instantly I died. Now a case was started where the content of the letter, date of the letter, signature on the letter, entry of the letter was in question. Now it is not possible to bring me in court because I am no more. Now, in discharge of my professional duty, in course of my ordinary course of business, I took the letter, stamped it, signed it, put date and entered the content in the GD book. Now this date, stamp, entry in the GD book, all will become relevant. Or against interest, number 3, or against interest of maker. When the statement is against the pecuniary or proprietary interest of the maker making it, or when, if true, it would expose him or would have exposed him to a criminal proceeding, criminal prosecution, or to a suit for damages. Number 3, when the statement made by the person who is right now not available for any reason as mentioned in section 32, first paragraph of this section, but the statement is against the pecuniary or proprietary interest of me. And when, if the statement becomes true, it would have exposed me to a criminal prosecution. I am the duty officer of the police station. I received some complaint of murder. I took the complaint, but I didn't take any steps there against. I told my colleague that I got bribe of rupees 5 lakhs. So I suppressed the matter. Thereafter, after 3 days, I died. So if this statement is against me, and if this statement is proved, it will expose me to a criminal prosecution. So this statement will become relevant. Or gives opinion to a public right or custom or matter of general interest. When the statement gives the opinion of any such person as to the existence of any public right or custom or matter of public or general interest, of the existence of which, if it is existed, he would have been likely to be aware, and when such statement was made before any controversy as to such right, custom or matter had arisen. Statement made relating to public right or any custom or any matter of general interest. Statement made by a person. I have 5 kathas of plot of land. Out of that 5 katha, the extreme front 1 katha is being used by the public for accessing the main road. And at that time, when I admitted it, when I made this statement to B that I am the owner of this 5 kathas of land, that is true, but the extreme front 1 katha is being used by the public in general for accessing the main road. When I made this statement to B, there was no dispute arose regarding this 1 katha, whether it is being used by the public for accessing the main road or not. There was no dispute. So this statement will become relevant. 5. Or relates to existence of relationship. When this statement relates to the existence of any relationship by blood, marriage or adoption between persons as to whose relationship by blood, marriage or adoption the person making the statement had special means of knowledge, and when the statement was made before the question in dispute was raised. Marriage between A and B. The marriage is not registered, and they used to reside together as a husband and wife in a family where parents of A, I mean the husband, used to reside, brother of A, I mean the husband, used to reside, and the parties, the husband, wife A and B, used to reside in the same family under the same roof. Now after 5 years, A filed a suit that B is not the legal wife of me. Now the parents, the brother of A had special knowledge that B is the wife of A. So this statement will become relevant if it qualifies either of the terms stated in the section 32, first paragraph of this section, or is made in will or deed relating to family affairs. Anything mentioned in deed or will relating to family affairs. How is that? When the statement relates to the existence of any relationship by blood, marriage or adoption between persons deceased and is made in any will or deed relating to the affairs of the family to which any such deceased person belonged to, or in any family pedigree, or upon the tombstone mentioned, family portrait, picture, or other thing on which such statement are usually made, and when such statement was made before the question in dispute was raised. Subsection 6 will be clear from the illustrations, so I am not explaining it right now. I am coming to subsection 7. Or in document relating to transaction mentioned in section 13 clause A. When the statement is contained in any deed, will or other document which relates to any transaction as is mentioned in section 13 clause A. What is in section 13 clause A? Where, read the section with me, where the question is as to the existence of any right or custom, the following facts are relevant. Any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted or denied, or which was inconsistent with its existence. If, when the statement is contained in any deed, will or other document which relates to any such transaction as is mentioned in clause A, section 13 clause A. So in section 13 clause A, the nature of the transactions which are mentioned there, if those are mentioned in any deed, will or other document, that will become relevant. Subsection 8, or is made by several persons and expresses feelings relevant to matter in question. When the statement was made by a number of persons, more than one, and expressed feelings or impressions on their part relevant to the matter in question. This subsection will also be cleared from illustrations. Now I am coming to the illustrations. Illustration A. The question is whether A was murdered by B. Listen very minutely. The question is whether A was murdered by B, or A dies of injuries received in a transaction in the course of which she was ravished. The question is whether she was ravished by B, or the question is whether A was killed by B under such circumstances that a suit would lie against B by A's widow. The statement made by A as to the cause of his or her death, referring respectively to the murder, the rape, and the actionable wrong under consideration, are relevant. I discussed this point earlier. Now I am coming to illustration B. The question is as to the date of A's birth. This relates to subsection 2. Date of A's birth. Any entry in the diary of a deceased surgeon regularly kept in the course of business. A surgeon, he regularly maintains a diary where he enters the birth of every child in his hand. An entry in the diary of a deceased surgeon regularly kept in the course of business stating that on a given day he attended A's mother and delivered her son is a relevant fact. Very easy. It explains subsection 2. Subsection 3. The question is whether A was in Calcutta on a given day. The statement in the diary of deceased solicitor regularly kept in the course of business that on a given day the solicitor attended A at a place mentioned in Calcutta for the purpose of conferring with him upon specified business is a relevant fact. Being an advocate, I regularly maintain a diary that today I met such and such clients at such and such time and such place. I died. But in the diary, it is mentioned that I met A on a particular day in a certain place in Calcutta. This entry will become relevant. This also explains subsection 2. Illustration D. The question is whether a ship sailed from Bombay Harbour on a given day. A letter written by deceased member of a merchant's firm by which she was chartered to their correspondents in London, to him the cargo was consigned, stating him that the ship sailed on a given day from Bombay Harbour is a relevant fact because this is in ordinary course of business. In ordinary course of business, she mailed the letter. This letter contains date, time, place, everything. So this letter will become relevant. Illustration E. The question is whether rent was paid to A for certain land. A letter from A's deceased agent to A saying that he had received the rent on A's account and held it at A's order is a relevant fact. This is number 3, subsection number 3, against the interest of the maker. Why it is against the interest of the maker? Because and a letter from A's deceased agent to A. The agent wrote to A that he received the rent on A's account. Now the liability of the maker starts, and held it at A's order is a relevant fact. And the agent also admitted that the amount is with him. So this goes against the maker of the statement. If the statement is true, it is the liability of the statement maker to make payment of the rent he collected from the tenant to A. So it will become relevant. Illustration F. The question is whether A and B were legally married. The statement of a deceased clergyman that he married them under such circumstances that the celebration would be a crime is relevant. It explains subsection 4. Illustration G. The question is whether a person who cannot be found wrote a letter on a certain day. The fact that a letter written by him is dated on that day is relevant. The question is whether a person who cannot be found wrote a letter on a certain day. The fact that a letter written by him is dated on that day is relevant. Very easy. Nothing to explain further. H. The question is, what was the cause of the wreck of a ship? A protest made by the captain whose attendance cannot be procured is a relevant fact. The question is, what was the cause of the wreck of a ship? A protest made by the captain whose attendance cannot be procured is a relevant fact. The question is whether a given road is a public way. A statement made by a deceased headman of the village, that the road was public is a relevant fact. It explains subsection 4. It explains subsection 4. Illustration J. The question is, what was the price of grain on a certain day in a particular market? A statement of the price made by a deceased baniya means businessman. A statement of price made by a deceased baniya in the ordinary course of his business is a relevant fact. A businessman who used to do his business in that particular market made a statement that the price of wheat is such and such on this date. This will become relevant. Illustration K. The question is whether A, who is dead, was the father of B. A statement by A that B was his son is a relevant fact. It describes 5 and 6. The question is whether A, who is dead, was the father of B. A statement by A that B was his son is a relevant fact. Come to the next, L. The question is, what was the date of birth of A? A letter from A's deceased father to a friend announcing the birth of A on a given date is a relevant fact. Nothing to explain. Very, very nice illustrations. M. The question is whether and when A and B were married. An entry in a memorandum book by C, the deceased father of B, of his daughter's marriage with A on a given date is a relevant fact. Illustration last. N. A sues B for a libel expressed in a painted caricature exposed in a shop window. The question is as to the similarity of the caricature and its libelous character. The remarks of a crowd of spectators on these points may be proved. It explains the subsection 8. So I think section 32 is clear. It will be further clear when I will discuss the case laws in part 2 of this video. And now I am coming to section 33. Relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage at the same judicial proceeding the truth of the facts which it states. Only the truth of the facts which it states will become relevant. When the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party, other side, or if his presence cannot be obtained without an amount of delay or expense which under the circumstances of the case the court considers unreasonable, provided that the proceeding was between the same parties. Condition: the proceeding was between the same parties or their representative in interest, and the adverse party in the first proceeding had the right and opportunity to cross-examine. So the subsequent proceeding where I am trying to utilize a statement made in the first proceeding, the subsequent proceeding must be between the same parties or their representative in interest, and the statements made in the first case, earlier case, there the adverse party must had the opportunity to cross-examine the maker of the statement. That the question in issue was substantially the same in the first and in the second proceeding. Questions in issue were substantially same in the first and the second proceeding. Explanation: a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. So the basic thing for this section is a case between the same parties where, say, case between A and B. A made some statement in the first suit. After that, say A died, and B had the opportunity to cross-examine A in the first suit. Now the second case is either between A and B or their representative in interest. Now any statement made by A, only the portion, the truth of the facts which it states shall become relevant in the subsequent suit. So I think I was able to explain you the section 32 and section 33, which is commonly known as dying declarations. I am ending the part 1 of this video now, and in the part 2 I will explain some landmark case laws so that you can understand these provisions, dying declarations, with further clarity. Till then, goodbye. I will request you to read the sections thoroughly. You will understand, and if you have any questions, any doubt in your mind, feel free to write to me or call me in the email ID and phone number given on the screen. Thank you very much for watching this video. Thanks.